Inge.
I get it. Under the circumstances, I wouldn't want to be anywhere near a police station if I were you either. I'll tell you what, the mahogany in my conference room is currently getting buffed out, so I'm using my satellite office at Juan Tabo and Skyline. I'm letting a nail salon, use the lobby, so my office is in the back. Meet me there at 3. Great, thanks. How's it hanging, Steve-O?
Shoes, belt, jacket.
Sorry, what?
Shoes, belt, jacket.
Seriously? Since when?
It's procedure, sir.
Sir? Why'd I hit the jackpot?
Never can tell.
Hey, how you doing on this beautiful day? Did you catch that cookie bouquet that I sent for Carlos's birthday? Because I put a few extra white chocolate macadamias in there just for you.
What do you need?
Me? Nothing. But I have a friend who could use a preliminary hearing rescheduled. Gonzalez v. New Mexico. And my friend is looking for Friday around 9 a.m. Before the judge's 4th cup of coffee, because caffeine jitters, they're brutal on the defense, so.
What friend?
I don't believe you two have met. What is this?
A hearing change request form.
Hey, come on, it's me. Look, Mommy, I just graduated. I can't use a pen. I have no opposable thumbs. Hey, Hannah Banana.
Hey, yourself.
Come on, Bill. That's the way to treat a lady. You gotta make love to it, Bill. Be gentle. That's the way to do it. Think Barry White. Think seduction. Voila. What the hell is going on? How come everyone's treating me like I'm covered in oozing pus sores?
I liked you better when you were just a regular bottom feeder. But this...
This? What is this?
I understand advocating for your client. Deep in my heart, I get it. But you scammed the court. You scammed the judge. And for what? To get a murdering cartel psychopath back out on the street? It's just... wrong.
It's a lot of big talk, Bill. Prove it. Prove it, Bill!
right, good morning. We are on the record. 29222805. This is State of Idaho versus Bryan Kohberger. Mr. Kohberger is in custody. He is appearing here in court with his attorneys, Ms. Taylor, Mr. Logsdon. Mr. Thompson, Ms. Jennings appearing on behalf of the state. This is the time set in the matter for the preliminary hearing status conference. So I am going to inquire of counsel. Ms. Taylor, what's the status at this time?
Thank you, Your Honor. We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing. Mr. Kohberger understands his right to a timely preliminary hearing, and he's willing to waive the timeliness to allow us time to obtain discovery in this case and be prepared.
And Mr. Thompson, are you in agreement with that?
The state has no objection to that, Your Honor. Ms. Taylor reached out to us by email yesterday with her proposal. On reflection, the state's calendar would be better in the month of July, but we will make the end of June work if that's the court's preference. And I haven't had a chance to talk with Ms. Taylor about that. I'm sorry, I know that's last minute.
That's okay. The court's calendar is going to be better towards the end of June, early July. So would that work, Ms. Taylor, for your scheduling on your other matters?
Your Honor, yes, if we take that 4th week in June, that's actually best.
Okay. So, Mr. Kohberger, I need to speak to you for a moment then. Sir, you do understand, and Ms. Taylor has represented here, that she's advised you of your right to have, or fully discussed with you, the right that you have, which is to have your preliminary hearing within 14 days of the date that you initially appeared before this court. As you recall, when I advised you of your rights, that hearing is a probable cause hearing where the state has to establish that more likely than not, these felony offenses were committed and you were the one that committed the felony offenses. If you waive your right to a speedy preliminary hearing, it does not mean that you're giving up your right to have a preliminary hearing. It simply means that you would not be able to come back and challenge that the state did not present probable cause within 14 days. Do you understand?
Yes.
Have you had enough time to speak with Ms. Taylor about your decision to waive your right to a speedy preliminary hearing?
Yes.
Do you need any additional time to do so?
No.
Then I will ask at this time, as to the 5 counts, felony counts that were charged in the criminal complaint that was filed on December 29th of 2022, are you waiving your right to a speedy preliminary hearing and agreeing that that hearing can be held outside the 14-day period?
Yes.
And Ms. Taylor, do you concur with his waiver?
I do, Your Honor. Thank you.
I will find your waiver of speedy preliminary hearing is knowing, intelligently, voluntarily entered here in open court with the assistance of counsel. We will go ahead and set the matter for preliminary hearing. Beginning Monday, June 26th at 9:00 a.m. And I will go ahead and reserve the week, so June 26th to June 30th, in the event that we need all 5 days for presentation of evidence. And just so council knows, it will begin at 9 a.m. each of those days. Is there anything further to address at this time in the case, Mr. Thompson?
Not from the state's perspective, Your Honor, no.
All right. Or Ms. Taylor?
No, Your Honor. Thank you.
Okay. Mr. Kohberger, then you will be remanded into custody on your same no bail at this point in time, pending further proceedings. Again, we'll send notice out to council, and we will be in recess for this morning.
Thank you, Your Honor.
Thank you.
Mistake number 7. Failing to take advantage of a preliminary hearing. A preliminary hearing, also called a probable cause hearing, is an opportunity for the defense attorney to ask questions of the prosecution's witnesses. The hearing is under oath, so the witness may be impeached at a later trial. If the hearing is successful, meaning that the charges are dropped, you will lose your bond. If unsuccessful, your bond remains. See mistake number 4. Most defendants do not want to win the hearing for this reason. Even if the charges are dropped, they can be brought back if the defendant is indicted by the grand jury. This is not considered double jeopardy. Instead, these defendants want to take advantage of the hearing by cross-examining the state's witnesses and hearing what they are going to say. The main purposes of a preliminary hearing are: 1. To learn what the witness will say at a later trial. 2. To investigate the truth of the testimony before a later trial. 3. To lock in the testimony of the witness for later impeachment. And 4. To seek a lower bond or lesser charges before the case is indicted in criminal court. Some attorneys flap a lot about how they are going to subpoena the state's witnesses to see if they dare to show up. Then, when the witnesses appear and it is time for the attorneys to have a preliminary hearing, these attorneys flinch and say, "You don't want to have this hearing." This opportunity should be more than just a gamble to see whether someone shows up. If the witnesses show up, then you should have the hearing in almost all cases. If you are planning to take your case to eventual trial, then the preliminary hearing is the opportunity to start prepping the case. Juries love it when a witness gets caught fibbing. The attorney has that high drama moment when he or she can say, "That's not what you said last time." The problem is that if there is no last time, there is no prior testimony to impeach. Unfortunately, some attorneys don't believe that certain defendants deserve a trial because their charges are not serious enough. They may say, "Oh, take the diversion and it comes off your record," when you still want to fight the case itself. A diversion is a wonderful thing, but if you want to fight the case first, then make that clear when you hire the attorney. This mindset actually punishes you for having a clean criminal record.
Now he's presumed innocent. That's the other thing you want to see in court. Is he acting like someone who's been wrongfully accused of the highest profile crime in the nation? So he was in court today. Let's take a look.
So, Mr. Kohberger, I need to speak to you for a moment then. Sir, you do understand, and Ms. Taylor has represented here, that she's advised you of your right to have, or fully discussed with you the right that you have, which is to have your preliminary hearing within 14 days of the date that you initially appeared before this court. As you recall, when I advised you of your rights, that hearing is a probable cause hearing where the state has to establish that more likely than not, these felony offenses were committed and you were the one that committed the felony offenses. If you waive your right to a speedy preliminary hearing, it does not mean that you're giving up your right to have a preliminary hearing. It simply means that you would not be able to come back and challenge that the state did not present probable cause within 14 days. Do you understand?
Yes.
Have you had enough time to speak with Ms. Taylor about your decision to waive your right to a speedy preliminary hearing?
Yes.
Do you need any additional time to do so?
No.
Then I will ask at this time, as to the 5 counts, felony counts that were charged in the criminal complaint that was filed on December 29th of 2022, are you waiving your right to a speedy preliminary hearing and agreeing that that hearing can be held outside the 14-day period?
Yes.
And Ms. Taylor, do you concur with his waiver?
I do, Your Honor. Thank you.
I will find your waiver of speedy preliminary hearing is knowing, intelligently, voluntarily entered here in open court with the assistance of counsel. We will go ahead and set the matter for preliminary hearing. Monday, June 26th at 9:00 a.m. And I will go ahead and reserve the week, so June 26th to June 30th, in the event that we need all 5 days for presentation of evidence. And just so council knows, it will begin at 9 a.m. each of those days.
Hi, my name is Mark D. Kopolis, and I'm a Philadelphia criminal defense and real estate lawyer. And this is my Philadelphia criminal law blog. One question I get a lot when people come into my office is, what is a preliminary hearing? And should you waive your preliminary hearing? And tonight I would like to talk a little bit about that. In the county of Philadelphia, and this is specific to Philadelphia because I practice in Philadelphia, you basically have a right to a preliminary hearing if you've been charged with a felony offense, not an ungraded felony, a felony 3, 2, or 1 in the county of Philadelphia. And what is a preliminary hearing? Basically, it's a chance for a judge to hear the facts of the case, to hear a basic outlay of the Commonwealth's facts to decide, is there something here? Is there basically a basis for this case to go forward? And the idea behind it is, if you're facing a felony offense, an F3, an F2, an F1, something that carries a maximum of somewhere between 7 and 20 years in prison, something that may go for years, it's a good idea to have a judge listen at the very beginning of the case to decide, is there something here? Because in a lot of situations where you're facing a felony offense, the defendant may not go to trial for 2 years. And so the idea of the preliminary hearing is to get this case in front of a judge, to hear the facts and decide, is there a prima facie case against this defendant? Now, what's that's loosely correlated to is the judge convinced, more likely than not, that the defendant committed the crimes that are alleged? Now, while more likely than not may not be the official standard, that is kind of the common standard that's used in the courts. Is the judge convinced, more likely than not, that the crimes that are alleged were committed?
South of Moscow on US 95 is the path that you put in your search warrant and affidavit alleging that Bryan Kohberger left Moscow going south on US 95.
Yes, ma'am.
All right.
I just want to clarify what's in your probable cause affidavit. Does your probable cause affidavit state that Kohberger or a white Elantra went on US 95 south of Moscow?
No, it's not.
Okay. What does it state?
Memory serves, states that the next time, it states that a vehicle was seen leaving the area of the crime scene, McKean Road, leaving via Walenta Drive, which heads south from that area, and then terminates on Conestoga and Moose River Drive. That's what the probable cause affidavit states.
And to your knowledge, are there other paths of travel south of Moscow besides US 95?
Yes.
And what's that other route?
I believe the one that was referenced in the affidavit goes from Moose River Drive, which turns into Sand Road at the state line, not the Idaho-Washington state line. That road continues westbound until south of Pullman and eventually leads north into Pullman at Bishop Boulevard, if memory serves.
And does that path of travel go by Wasson Carry Construction?
I do not believe it does.
Did you attempt to obtain surveillance on that path of travel that doesn't go through 95?
Yes, we did.
And were you successful?
I don't believe we were.
I don't have anything further.
Okay, thank you. Ms. Taylor?
Are you testifying that Mr. Kohberger did not use Highway 95 south of Moscow on November 13th?
I'm testifying that there are various routes that a person could take south of Moscow to include Highway 95. There are also several others.
Which one does your map depict?
I believe the map starts well south of Moscow, forward more towards Genesee, and there is the line that starts there. However, I would direct you to the paragraph at the beginning of the map that says this is a possible route to travel between the two locations.
So you're just not sure.
Yes, ma'am.
Okay. That would include then Highway 95 south of Moscow.
Yes, ma'am.
And that would include other possible routes.
Yes, ma'am.
How many video surveillance attempts did you make to get video from businesses or homes on all of those routes?
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Not one video depicting the car.
To my memory, no.
Good enough, thanks.
All right. Thank you.
And if the Commonwealth cannot prove at the preliminary hearing a prima facie case that the defendant committed the crimes, then the charges are dismissed and the case is over really before it even began. And that kind of takes me to the second question, which is, should I waive my preliminary hearing? Now, there's an exception to every rule, but I would say that in at least 80% of the cases, probably about 80%, kind of going back to the 80-20 rule, 80% of the time, I would say absolutely not. You should not waive your preliminary hearing. Why? Because you're getting a sneak preview of the Commonwealth's case. The Commonwealth is going to call all their witnesses, or at least the witnesses that they need to prove the essential offenses of their case, and your defense attorney is going to have a chance to cross-examine those witnesses, to ask those witnesses some questions, if the judge is lenient, potentially get some information to prepare for motions that may be litigated down the road. Because it's a jury demand, you're going to have a preliminary hearing. You go in, the police officer goes in, the police officer is going to get up there and testify to everything that's probably going to happen at the trial in 6 months, 1 year, 2 years down the line. This is your chance to get information from that witness and start getting ready for your case ahead of time. It's a sneak preview. And so you shouldn't waste that opportunity and just waive your preliminary hearing if you have a chance to cross-examine that officer. Maybe that officer is going to say something on the stand that contradicts what's in his police report. Or maybe he'll say something at the preliminary hearing that's inconsistent with what he's going to say in the trial in 2 years. And because you had that preliminary hearing, because you were able to lock him into his testimony, you're going to have another chance to impeach that officer that you wouldn't otherwise have. So there's really no reason to waive a preliminary hearing. In addition to that, maybe the Commonwealth completely drops the ball at the preliminary hearing, and the case is dismissed by the judge for lack of prosecution if they don't bring their witnesses in. Or the judge decides, you know what, I heard the facts and I'm not convinced, more likely than not, that the defendant committed these crimes.
Welcome back to CBS Mornings, where we have got a story for you. Earlier this month, 35-year-old Sheldon Thomas walked out of a Brooklyn, New York courtroom free after almost 2 decades behind bars. Thomas was arrested back in 2004 for murder after an eyewitness pointed to a picture of a guy named Sheldon Thomas in a police lineup of photos. But the man in the image was actually a different person entirely, happened to have the same name. And as we step through the circles of absurdity here, that guy also had no link to the case. Nevertheless, prosecutors continued to focus on the Sheldon Thomas they had in custody, which eventually led to his wrongful conviction. Thomas talked to our Lilia Luciano just days after his release in his very first TV interview.
I waited for this my whole life.
Sheldon Thomas was 16
when police took down the door of his home and locked him up. Now, 19 years later, he's been effectively exonerated.
What's been hard about just being out and about? It's been so little time.
Just like what you said, being out and about, adjusting, being around people.
Thomas was convicted for second-degree murder in the December 2004 death of a 14-year-old boy in Brooklyn. Attorneys William Kasten and Leslie Ressinger have worked with Thomas for more than a decade. They say the case should have never even made it to trial.
How much of his case was based on lies?
100%. From the police interaction to him, every party failed him in the system.
In a pretrial hearing, a detective lied, then admitted to lying on the stand, and the case still moved forward.
He is arrested based on a photo that is not his.
The people involved in decision-making refused to accept the fact that a mistake was made. How can a jury reach a fair verdict? It was rigged from the start.
The unit that reviewed his case after years of failed appeals concluded that Thomas was denied due process at every stage and found one of the detectives involved had been harassing Thomas after a prior arrest and lied about knowing him.
Did you ever feel like they were targeting you specifically?
Most definitely.
It should have been the other way around. You're innocent until proven guilty.
From my lenses, the way I see life, it's always like that for people like me, for people that look like me.
They've been living a nightmare, not to mention the nightmare that the families of these 4 victims will continue to live as this trial gets underway and the case pushes forward. I want to welcome in now Jonna Spilbor. She is a criminal defense attorney. She's done a lot of research on the death penalty, which Idaho does have. She's also worked in a city attorney's office. Jonna, thank you for being with us this morning. So this is a status hearing tomorrow where Bryan Kohberger will appear before a judge. What should we expect?
Okay, well, a status hearing usually is not anything monumental. It's basically an opportunity for the judge and the counsels, defense attorney and prosecutors, to figure out what the next steps will be. In a case like this, as a matter of fact, in any case where somebody is being held behind bars without bail, due process kicks in. And the defense attorneys are either going to have to schedule what we call a preliminary hearing to challenge the probable cause, or Mr. Kohberger needs to be indicted by a grand jury. One of those two things needs to happen in order to justify keeping him in custody. My guess, if we have no surprises, will be they will schedule this for a preliminary hearing, if there are no surprises.
So it's really a chance to jump on a criminal case right away. There's a lot of defendants who will just wait to hire a lawyer until after the preliminary hearing. They think, oh, well, it's just preliminary, it's not that important. I'm going to save my money and get the lawyer after the preliminary hearing. I would advise against that. Obviously, I'm biased, but the reason I advise against it is because it gives your lawyer a chance to get the facts of the case right off the bat. And that is invaluable when you're preparing for the case 6 months, 1 year, 2 years down the line, when you can go back to those preliminary hearing notes, because everything that's said at that preliminary is being typed down. You can look at those notes and you can say, he said this, in his police report he said that, and at trial he's going to say that. And you can use those preliminary hearing notes to impeach the Commonwealth's witnesses further down the line. So my advice would be, as a general rule, do not waive your right to a preliminary hearing. Make them prove their case. Make them prove it at a prima facie level, because you may be able to use that evidence somewhere down the line. And you may even get the case dismissed. My name is Mark D. Kopoulos. I'm a Philadelphia criminal defense and real estate lawyer. If you have any questions about a preliminary hearing or need representation at a preliminary hearing, please don't hesitate to contact me. My office can be reached at 267-535-9776. Thank you.